Good afternoon, ladies and gentlemen. My name is Olesia Liashevich, and I am a junior legal officer in the legal department of GeoSco. Today, I will be presenting the merits of the statement of defense in response to the submission of the claimant, Drone Co. The claimant submits that the drone model G2010 does not qualify as an aircraft, and therefore the CIG governs the agreement. However, the respondent states that the drone is an aircraft and the tribunal should find that the CIG does not apply to the agreement. The respondent also relies on the CIG to avoid the agreement due to nonconformity. The issue at hand is whether the CIG applies to the current agreement between the parties, given that the claimant argues that the drone model G 2010 does not qualify as an aircraft, while the respondent claims the opposite. To determine whether the CIG applies to the agreement, we must first analyze the definition of aircraft under Article 2E of the CIG, which states that the convention applies to sales of goods defined as all things which are movable at the time of identification to the contract for sale. It also specifies that goods to be supplied to the buyer may be partly or wholly manufactured, processed, or developed by the seller. The term aircraft is not defined in the CIG, and there is no clear guidance on whether UAVs, such as the drone model G2010, should be considered aircraft under Article 2E. However, we can turn to scholarly analysis and case law for guidance. Firstly, it is worth noting that the size and design of the drone model G2010 are similar to those of a helicopter, which is generally considered an aircraft. Still, there is a dispute as to how to restrict the application of Article 2E of the CIG. Some scholars, such as Huber, Wallis, and Schwenzer, have argued that the term aircraft should be interpreted broadly. It has been suggested to restrict the provision to vehicles that have to be registered under domestic regulations to make the size the decisive factor, or to apply the provision only to vehicles which serve the purpose of transportation. Due to the fact that the drone model G2010 is 6 meters long, its size is similar to the size of a helicopter. Therefore, based on the drone size, it can be argued that drone model G2010 is an aircraft for the purposes of Article 2E. Moving on, secondly, the function and use of the drone model G2010, which includes the transportation of goods and other uses beyond surveillance, further supports the argument that it should be considered an aircraft under the CIG. According to the opinion of some scholars, particularly Franco Ferrari, the purpose of use of the drone is an important aspect in answering the question whether it falls under the term aircraft under the CIG. Therefore, if the purpose of the use of the drone was similar to that of an aircraft, the particular drone can be considered aircraft. This is also consistent with the purpose of the CIG, which is to promote uniformity in the international sale of goods, to include UAVs as they are capable of performing functions similar to traditional aircraft. The parties have unambiguously specified the use of the drone beyond surveillance purposes. It is a common fact that transportation is one of the vital features of an aircraft. The drone model G2010 is capable of transportation, and both parties had knowledge of that. The drone model G2010 was intended to be used as an aircraft, and therefore CISG should be applicable to the agreement. In the light of the above, it is my recommendation that the respondents take the position that the CISG applies to the current agreement, despite the claimant's argument to the contrary. Regarding the issue of nonconformity, it is necessary to determine whether model G2010 delivered by the claimant meets the agreed specifications and requirements of the contract. If the drone does not conform to the requirements set out in the contract, the buyer may avoid the contract under Article 49 of the CISG. According to Article 35 of the CISG, the seller must deliver goods that conform to the contract. If the goods delivered do not conform to the contract, the buyer may avoid the contract under Article 49(1)(a) of the CISG. Under Article 25, the nonconformity must be substantial enough to affect the essential purposes of the contract. In the present case, the respondent alleges that the drone delivered by the claimant is not state-of-the-art, as required by the tender and contracts, and therefore does not conform to the contracts. Indeed, the drone model G2010 cannot be considered a state-of-the-art in light of the fact that claimant has released a newer model 2020, just a few months after the conclusion of the contract. The claimant knew that a newer model was to be released soon, but decided to sell an older model to the respondent. This could be considered a breach of the contract, and the respondent may avoid the contract under Article 49(1)(a) of the CISG. In conclusion, it appears that the respondent may have a strong case for avoiding the contract based on nonconformity. As a respondent, we request the tribunal to dismiss the claims of the claimant and to declare that the CISG does not apply to the agreement. Additionally, we ask the tribunal to find that the model G2010 qualifies as an aircraft, and therefore the agreement falls outside the scope of CISG. Furthermore, we request the tribunal to reject the claimant's request for damages and order the claimant to pay for the costs of the proceedings. Thank you.